তো ভালো নয়।
Can you mention it not in the list? That's great. Apologize. That the matter which was being heard last week about the university grants solution, global recall, I had a suggestion on quality that UGC had filed its reply for the private. But it's not there in any of the paper books, so I checked my request is there. But I was playing leave to make copies and define the
Yes, yes. Is she there? Is she there? Give it to her.
There tomorrow. Before that, I just wanted that liberty to circulate.
Yes, yes. You do it. Should we record an order?
No, ma'am. But I just wanted that limited because I made a submission on another thing, so it needs to be.
Item 1116, 1956 and 27. One, previous.
Why? What is the problem today? He's for the petitioner. Appellant. Very well, but who's on your other side? You must inform your learned friend. Inform your learned friend. যেটা বলছে করে দাও, বুধবার দিন করে দাও। DB division bench.
Item number one, this madam appealing for the appellant by the CEO, the Bharat Mission Act of Police.
My lord, I am appearing for the petitioner side.
Yes.
My lord, my senior has gone to the Supreme Court in an urgent matter. So I am praying for not today or not tomorrow.
Lord, or as I am appearing for.
You are there. Why don't you do the matter? We have read the order. We have read the order that you have challenged. There's nothing wrong in the order. With your client's consent, the mark was deducted following the rules. Anyway, Wednesday, he's asking for Wednesday. On Wednesday, no further adjournment.
Okay, my lord.
You have to
Much
argue.
obliged. Much obliged.
But I'm for the smaller number.
Item number two.
Mr. Rakesh Kumar, adjust the microphone. Take the microphone.
Sir.
We have.
I put in that matter, Lord, 2, 3, 4, and 5 I am appearing. In that earlier matter.
Earlier matter?
That my lord is fixed it on Wednesday.
Yes.
That matter I am appearing for respondent number 2, 3, 4, and 5.
Very well.
Yes.
Item number two.
My lord, I am appearing for the petition. My lord, a paper publication was made on 1st of May 2002 for appointment to the post of peon under the Forest Department. My lord.
Isn't it covered by Justice Hiranmaya Bhattacharya?
Absolutely, my lord. Absolutely. That's why I have enclosed it. So they may make some argument, or if I jump into the judgment, my lord may say you place the fact. That's why I did not.
Yes, and then LDC. Peon
Yes.
and then LDC.
Similarly circumstances, and my lord has explained why, because the very purpose is to give relief to an incumbent.
Correct.
My lord.
So this word immediately.
Yes, that has been
been interpreted.
Yes,
in a
reasonable
manner.
Within a reasonable period.
Yes, Mr. Rakesh Kumar. As I understand, you can follow. I have read it. Now it's fully covered.
Yes.
I understand because this is a judicial precedent when the court has decided. But the only aspect is that not be immediately. In that case, there was a duration of 11 days.
Yes.
But in this case, it was around a duration of 186 days.
But how soon after joining the new post did he inform? How soon?
That's why it is after the period of 186 days.
Where he first joined the post of
Peon.
peon.
Peon?
Then once the result came out for LDC
Yes, sir.
and he found his name there, he joined the post of LDC once he was offered. After that, when did he inform?
But when the result is, when he has joined as a peon,
Mhm.
and thereafter he has, as per the OM,
Give us the dates,
Yes.
very simple.
My lord,
no,
he.
he was,
Yes.
no, he was joined as a peon on 12th September 2006.
Yes.
15th September.
15th September, he reported as a duty.
12th March 2007, he was appointed to.
1 second. 12th September
2006, he received the appointment order
for peon.
for peon.
Then
15th September 2006, he reported duty.
very well.
12th March 2007, he was appointed to the post of lower grade clerk.
12th March 2007. LDC appointment.
And 14th March 2007, he informed and tendered resignation.
Then there is no delay. Once he joined the new post, he immediately informed.
No right
No,
was.
no, because the rule says if my lord will see 2.2.1, when he joins as a peon, he has to be intimated that he has applied for certain posts. That's the order, my lord. My lord,
Anyway, beneficial legislation, Mr.
Yes.
Kumar. If you have something to argue, otherwise we'll reserve order. We won't waste court's time and we'll dictate.
I will not trouble this honorable.
And my lord, that judgment,
You see, you could have taken up that judgment by way of appeal to the Supreme Court. You have not done it.
Till as per instruction, we have not done.
We are bound by it. It's a coordinate bench.
Till.
and my lord has considered the latest judgment of the Supreme Court of 4th September 2025, my lord, which says that even administrative law, this is applicable. This is handmaiden law. It cannot be used to discriminate a person, my lord. This judgment I have placed before the division bench.
Very well. Then we'll pass the order in chair.
No, my only submission is that the delay part. Because the rule says when he has joined as a peon, he should have been informed that he has subsequently applied for another post. That was the OM. In that case, it was within a duration of 11 days, but
What benefits is supposed to use? What are the benefits?
because it will be create a precedence, because that is the difficulty. I argued that.
Where state? What is it? Yeah.
But the other submission is that, page number 93, the office order which says, is accepted. The resignation was tendered and it was accepted without invoking any clause of rules.
No.
This is
Citizens, minor. Not a major.
And even the judgment of the tribunal was similar judgment was passed. And both were rejected on by the same order. The candidature of the earlier incumbent and this incumbent were rejected by the authority.
Very well. We have heard the counsel for the parties. We'll note your argument. You are relying on rule 2.2.1.
one.
That has been reproduced in Justice Bhattacharya's
Yes,
judgment.
Yes, my lord, it is there.
You only in respect of item number 2.
Only in respect of item number 2.
We have heard learned counsel for the parties. Stop. Let this matter be listed once again under the heading for orders on next Monday.
Obliged.
Send it, dictate in the chamber.
Item 3, W55 or 2023. I am for the petitioner, my lord.
Yes,
I just served a copy upon my lord.
you've just served.
Yes.
When will you come back?
Day after tomorrow.
Yeah. Day after tomorrow, Wednesday.
Item number 4. At 33 of 125.
This matter, I'm appealing for the appellant, my lord. I pray for not today, my lord.
Why?
Because, my lord, the senior counsel, he would be arguing the matter tomorrow itself.
What is this every day?
Because,
you
my
take
lord,
time.
affidavit
Not
of,
today.
my lord.
Hey, on the prayer, Stephen. On the prayer made on behalf of the appellant, let this matter stand adjourned for the day.
Item number 5. That's 46 of 125.
But I'm there for the appellant. During the last circuit, this appeal virtually was heard out. And we were asked to put the written notes and argument on record. I put it. I can just recapitulate the points, my lordship, so that I can elaborately argue on.
Why is it appearing under the heading for admission?
It's being done long ago, my lord. It's being done long ago. Paper book has been filed, everything is brought on record.
No, so this is a hearing matter. Let it be listed under the heading. Yes. Hey, this should be under the heading hearing amongst the first 5 items.
I'm extremely objective.
Here you.
Sufficient time with the
Yeah, I've received the paper book.
This is also paper book file. Then why for admission?
My,
Hey, you admission আসছে কেন বাবা? Paper book হয়ে গেছে.
there was a direction, my lord, on the earlier occasion to pay.
Not to be listed under the heading for
No,
admission.
not at all, my lord. It ought to be under the
Hearing
heading
matters.
hearing.
Put it under hearing. You know? Tomorrow itself, put it under hearing.
Some, no. Practically.
106.
For the appellant, I saw the.
My lord, I am appealing for respondent. Today I filed my Calcutta, my lordship, in the office of registration.
Oh, I see. You filed for divorce?
Filed for divorce because.
Dismissed. This appeal is directed against a judgment and order dated December 30, 2025, whereby the appellant's suit for dissolution of marriage has been dismissed. Stop. Paragraph. Let the trial court records be called for. Stop. The department shall prepare requisite number of paper books once the trial court records arrive. Stop. What else? Nothing else.
After application paper book, letter will be issued.
Huh? Appellant করবে তাই?
No,
Oh,
cost.
you will prepare.
I will put the cost.
The appellant shall put হবে না? No, then it will never be done. We don't have the requisite. You do it yourself.
4 weeks time will be given.
Not department. Then say the appellant shall prepare requisite number of paper books, incorporating therein all papers that were available before the learned trial court, within 4 weeks from date. So, notice of appeal is dispensed with since the respondent is represented.
Even I filed Calcutta, my
You learned lawyer. Paragraph, list the matter after 4 weeks before the then available circuit bench, subject to its convenience.
Item number 9.
My lord, I am appearing for the petition, my lord. Appellants, my lord. Here,
I pay for the respondent one.
my lord, My lord, the land belongs to my paternal uncle, and we are the only legal heirs of Subhash Chandra Gain. Now, my lord,
We meaning the
appellants, my lord.
appellants.
Appellants. Now, what happened, my lord? After his death, because during his lifetime, he allowed the respondents to look after the affairs of the said plantation. After his death, also we allowed them as a licensee to look after the affairs. 2006, under the dint of a sale agreement, the opposite party applied for mutation of the subject land. Sale agreement, my lord. 2007, the Tahsildar rejected it as not maintainable. Since on the basis of sale agreement, no mutation between it is not a conveyance. Now, after this, my lord, the Tahsildar directed to approach the civil court. We approached the civil court for declaration and all. We were unsuccessful before two court. They did not file any case before any court of law. Now we have filed a second appeal before this court. Now, during the pendency of this, once again, on the basis of a sale agreement, they applied before the Tahsildar for mutation. Now, when they made this application, my lord, Tahsildar was not doing anything because already the Tahsildar said it is not maintainable. Now they approach this court. They approach this court and obtain an order. If my lord sees the language of the order says it has been read as it is a sale deed. My lord, may kindly come to page 83.
Oh, you were not a party.
Not the party. The cost title of the said writ petition was in the name of the power of attorney holder. Sagar Bhamik is the power of attorney holder. Sagar Chakravarti. He is a power of attorney holder. My lord, may kindly see, come to page 83, my lord. I have enclosed the entire writ petition. They kindly see the order, my lord.
Just allow us to read
My
the
lord,
order.
my lord. Same deed word was used, my lord. My lord, may kindly consider this. अच्छा, और रेट में तुम सेल एग्रीमेंट लिखी है तेरा तेरा तरफ से कोई सप्रेशन नहीं है लेकिन वो लोग जो एप्लीकेशन डाला ना उसमें रजिस्टर्ड डीड लिखा है तुम करेक्ट लिखिए सेल एग्रीमेंट हाँ नहीं यहाँ में तुम करेक्ट लिखिए वो लोग डीड लिखे ना
Who is Paresh Chandra Gain?
Paresh Chandra Gain is the husband of the appellant number 1 and the father of the appellant number 2.
Your group. Your group.
My lord.
Mr. You participate?
My lord, when an application is not maintainable in law, my lord, may kindly see page 63, sale agreement. The language which has been used in the judgment is sale deed, my lord. It's a sale agreement.
We understand, but then these were not pointed out to the learned single judge.
We were not a party to that.
So therefore, we are granting you leave to approach the learned single judge.
My lord, grateful. I thought, my lord, this
Yes.
yes, that can be done, my lord. Absolutely, absolutely. With regard to declaration that there is a second appeal that I will satisfy this court, the issue. My lord, the issue is that if I am holding a sale agreement, I have to file a suit for specific performance. They never filed a suit for specific performance. They are asking the Tahsildar to mutate the land in their favor under the dint of a sale agreement, which is not a conveyance. And Tahsildar rightly in the year 2007 rejected it, saying that it is not maintainable. That is at page 69.
And then he asked you to.
Civil court.
They lost.
We lost, we have filed a second appeal before this court.
Finalized.
No, not finalized, my lord. Second appeal is pending before this court. That, my lord, that is altogether different
You're
aspect.
the Tehsildar.
No, I'm not the Tehsildar.
You're the
The
Tehsildar.
captain.
The land is as of date recorded in whose name?
My lord, I have enclosed the document also, my paternal uncle.
Your paternal.
Yes. They don't have any right at all, my lord.
Lordship may kindly see, the order was passed by the Honorable Single Judge, specifically that all parties should be given hearing before passing any order. They participated. They raised objection and now they have come challenging that order.
The hearing already held before the Tehsildar.
Yes, they participated.
What order was passed?
No order was
Order
passed.
hasn't passed.
Since they raised objection,
They have submitted some objections regarding that sale agreement and sale. agreement.
Tehsildar
All
gave
those
time to
pending
file their
before
written
the
objection. The proceeding is pending. He has not adjudicated.
No question of proceeding when it is not maintainable under the law.
No, you
The proceeding may
participated
not-
and now you are.
So he will accrue
Same.
jurisdiction.
These points
Tehsildar
they have
has to
raised
adjudicate.
before the Tehsildar. These points, they have raised it before the Tehsildar.
It was agreement.
Lordship.
My lord, it's suppression and my lord, prior to that, my lord may kindly see who has filed it. The power of attorney holder saying himself as a party, he has filed the, how the cost title can be changed.
51.
No.
Registered sale agreement. In paragraph 51, it was.
Madam,
categorically stated.
how does a sale agreement confer title in you?
Lordship, nobody is deciding title.
Why should there be mutation also?
Who is directed the Tehsildar to mutate the property? One petition was filed after disposal of the civil suit seeking mutation, and now he has to adjudicate whether it is a registered agreement or it's a registered sale deed.
You go, we are granting you leave to approach the learned single judge.
My lord,
We are adding you as a party to
My lord.
the writ petition.
my lord.
Issue, come.
Lordship, what will be the proceedings of Tehsildar which he has already
It cannot
initiated?
be.
State for the time being, and will abide by the result of the writ
Yes,
petition.
yes.
We are reviving the writ
Yes.
petition. Acha. First take, which is your leave to appeal?
My lord, I'm sorry, but
But the order was never against them, your lordship. Order was in favor of them and they were served with the notice. It is not that.
Madam, they would be affected. This is your client's malafide. Let us not, do not say more. We'll record these things in our orders. Somebody who will be affected is not made a party. How will the learned judge know? Because your client did not apprise the learned judge of all these things.
and my lord, the case was filed in the name of power of attorney holder.
Peter, yes, can one. Huh? This is an application for leave to prefer appeal against a judgment and order dated August 28, 2025, whereby a learned judge of this court disposed of WPA 427 of 2025. Stop, no, 25, by directing the respondent in the writ petition, being the concerned Tehsildar, to consider the writ petitioner's representation dated April 3, 2025, within a period of 8 weeks from the date of the order, after affording an opportunity of personal hearing to the petitioner as well as the other stakeholders, if any, in accordance with law, by way of a speaking order. Stop. The intending appellants were not made parties to the writ petition. Stop. Hence, they pray for leave of this court to prefer an appeal against the said order. Stop. They say that they are the owners of the land in question. Stop. Suppressing that fact, the writ petitioner sought mutation of the land in question on the basis of a sale agreement and not a conveyance. Stop. Paragraph, having heard learned counsel for the parties, we are of the view that the intending appellants have sufficient interest in the matter, stop, we allow this application. Can 1 is disposed of. Can 2 is delay.
Delay, my lord.
How much?
84 days, my lord.
Can 2, this is an application for condonation of delay of 84 days in preferring appeal against the judgment and order dated August 28, 2025, whereby a learned judge of this court disposed of WPA 427 of 2025. Paragraph, causes shown being sufficient, we condone the delay. Paragraph, can 2 is disposed of. Now take the appeal and can 3 together. By consent of the parties, the appeal and the connected application are taken up for hearing together. Paragraph, the respondent number, you are respondent number 1 or
One,
2?
one.
1. Herein, approach the learned single judge with the grievance that their representation, his representation dated April 3, 2025, made to the Tehsildar, Ferarganj Tehsil,
My lord.
South Andaman District, was not being considered. Stop. By the said representation, the respondent number
Actually, my lord, that was made by, yes,
Respondent number 2.
Respondent number 2. Tehsil.
by the said representation, the respondent, that is there. Let's stop. Then, by the said representation, the respondent number 1, oblique writ petitioner, by that representation, he did not seek mutation.
yes, page 82.
The respondent number 1, oblique writ petitioner, sought mutation of landed properties, of certain landed properties, as mentioned in the learned single judge's order. Stop. Paragraph. The learned single judge noted that there is a registered sale deed dated June 13, 1963, whereby the writ petitioner whereby the deceased husband of the lady whose power of attorney holder was the writ petitioner, had purchased the said landed properties from Sri Shubodh Chandra Gain. Stop. The learned judge therefore directed the respondent number 2 herein, being the concerned Tehsildar, to dispose of the representation of the respondent number 1, oblique writ petitioner. Paragraph. The appellants say that Shubodh Chandra Gain is their paternal uncle, since deceased.
Yes.
Stop. The learned advocate, they further say that the concerned landed properties were never transferred to the principal of the writ petitioner or to anybody else by executing registered conveyance. Stop. Hence, there could be no question of mutation of the concerned landed properties in favor of the writ petitioner or his principal, whose power of attorney the writ petitioner held. Stop. Paragraph. To our query, learned advocate for the Tehsildar tells us that the concerned landed properties still stand in the name of Subodh Chandra Gain in the land records. Stop. Paragraph. We therefore see that the learned single judge was not properly assisted in the matter. Stop. Admittedly, there is no registered sale deed in respect of the concerned landed properties. Stop. In our view, comma, the writ petitioner ought to have impleaded the present appellants as respondents in the writ petition, since any order passed on the writ petition would affect the present appellants. Stop. Paragraph. Hence, comma, without going into the merits of the case, comma, we set aside the order under appeal and remand the matter to be adjudicated afresh by the learned single judge having determination. Stop. We add. No, stop. Consequently, comma, the writ petition revives. Stop. We add the present appellants as party respondents to the writ petition. Stop. The writ petitioner shall add them as parties to the writ petition and serve all necessary papers to them or their learned advocate. Stop. Paragraph. The parties will be at liberty to mention the matter before the learned single judge for hearing, for fresh hearing. Stop. We clarify that we have not considered the merits of the case, which is for the learned single judge to decide after hearing the parties. Paragraph, the MAT or whatever MAT and the connected application stand disposed of. Yes. Before disposing of, the proceedings before the Tehsildar pursuant to the, since we have set aside the order that naturally goes.
Yes.
The proceedings before the Tehsildar, which were initiated pursuant to the order of the learned single judge, which we have set aside, comma, also stand set aside.
Yes, yeah. Because it flows from the order of the learned single judge.
Lordship, writ petition will be at liberty to use further affidavit because there was certain development. in
Yes,
the
yes. The writ petitioner and the respondents will be at liberty to use further affidavits before the learned single judge.
$84 days. And my lord, the connected stay application is also this.
Yes.
In this case, and the mother, I have moved a petition before the maintenance guidelines under the maintenance and welfare of senior citizens, parent of senior citizen, 2007. During the pendency of that proceeding, respondent to its daughter.
Your daughter?
Yes.
Respondent number 1, Alia. And who are the others? Who are these others?
They are SDM and the chief secretary.
Oh, I see.
Hello. During the pendency of that proceeding, this writ petition was moved without proceeding as a part. Only respondent number 2 and 3 was included and taken as stay order. Stay order was allowed
This number.
without
Stay of the maintenance proceeding.
maintenance proceeding. I was not there. Then when the court said to make me a party also, that time the copy was served and I was in a party. And then when I came to know about the stay order, I moved a CAN application before the court to vacate the stay. So during that time, at the hearing stage itself, the entire proceeding was paused by the single bench. So on the presumption that on the guilty,
Have you served?
no much, this time, first case.
Serve. You have to. Service the police. This appeal is directed against a judgment and order dated December 19, 2025.
Appearing, they are saying to.
Mr. Jayapal has.
Not most for all purpose, this has to be served to my clients, not most. If I accept, I will lose many things.
I see.
Kindly consider this.
No, it's all right. That is judgment and order dated December 19, 2025. Passed by a learned judge of this court, whereby WPA 557 of 2025 was disposed of along with CAN 1 of 2025. Stop. In effect, the learned single judge has quashed the proceedings initiated by the present appellant before the concerned tribunal, praying for maintenance,
Praying for cancellation of gift.
praying for cancellation of gift deed made in favor of her daughter being the respondent number 1 oblique writ petitioner. Okay. Paragraph. Let service be effected on the respondents and affidavit of service be filed in court on the next date. How soon can you come back? 3 days time. Thursday? List the matter on. Give the date.
Your Lordship, and for the petitioner, they were supposed to say about the increment, Your Lordship. This is that case, Your Lordship, pensionary benefit where increment was not added, Your Lordship.
Yeah.
That is a different thing, Your Lordship. It relates to the back wages, not with regard to the pensionary benefits and notional increment. I have seen that petition. That is a different petition. with
We'll
regard
have to see Ms. Nag since he is saying so. Bring that? Yes. Not today, no.
Wait, please, Your Lordship.
I am
appeal.
Hey, 11 test ki ho? Oh, acha.
Hello, this is my appeal. 13 and 14 are two appeals. One filed by the state and one filed by the victim in a case of acquittal. So both have been. State states he has been nothing specially. That the second I will start my appeal. So let me state that.
Conviction under? Oh, acquittal, sorry. And charge was under?
3 heads of charge. One was 376 grade, one was 312, was in miscarriage without consent. The third was 407. We promised to marry. The background of this matter is this. I am a police constable. I was then 23 years old. The accused was also a police constable from the same batch. He was posted with the same police station. Now, admittedly, they were both known to each other, they were both friendly with each other.
You,
Because
you,
you don't need to mention was.
you don't appear in this matter? Number 3. Mr. Shatodru was appearing before. Is Mr. Chakraborty is no more in the panel, I think. So should I request you to appear and record that your engagement should be regularized? When will you file your affidavit then? 25 February. Very well.
And this is the second.
I'll record an order, it will be easier for you. On February 24, 2025, time for the respondents to file affidavit in opposition was peremptorily extended till March 31, 2025. Stop. Paragraph. Learned counsel for the writ petitioner says that no such affidavit has been filed till date. Paragraph. I see that earlier, Mr. Shatodru Chakravarti, learned advocate, was appearing. Oh, yes.
That's why.
Let's cut this out. Mr. Rakesh Kumar, learned advocate, representing the respondents, is present in court. Stop. I request him to obtain appropriate instructions in the matter. Paragraph lists the matter once again, Friday's date, under the same heading. It's meaning, Ms. Das, let me not consume court's time by dictating it in open court. Hearing is concluded, stop, judgment is reserved. I'll dictate in chamber and give it. I've already indicated my mind. Okay, Stephen, hearing is concluded, judgment is reserved. এটাকে মনোজ আইটেম 4টাকে আমার চেম্বারে পাঠিয়ে দাও চট করে
And this Babita Das was appearing before the trial court and the first appearing. Now,
she's appealing for whom?
Trial court now, just for number 10 onwards.
Tell me what should I do? Yeah.
Copy, I because copy these send it measure. I can serve a copy to her because last one, it also this matter was discussed.
So take a copy, if you obtain instructions or authority to appear, where should I keep it? Not yet been served.
They are all brothers and sisters. That's one. They are dependent. Because the plaintiff, main allegation is against the plaintiff, Mr. Rakesh sir. But let.
Ms. Das, learned advocate who represented some of the defendants before the learned trial court, appears and says that she has not been able to obtain Wakalatnama till now. Stop. She also does not have a copy of the, she also does not have a copy of the civil revisional application. Have you given her a copy today? Paragraph. A copy of the petition has been made over to her in court today. She seeks a little time to obtain instructions. Paragraph lists the matter once again on Thursday. Give Thursday's date. They let it go up. What is this? Every day, hundreds of adjournment. You are there. Why won't you do it? Grab this opportunity. Argue a matter. This is not fair. Only prayer is expeditious disposal. So let me dispose of this application. That is the only prayer. That the trial court be directed to dispose of the matter, other suit, as soon as possible. Why should I keep this pending? Very unfortunate, very sorry. I am allowing your application. Are you following what I am saying? I am allowing your application. I'll record your objection. Yes. Now, here and now. Tell me. So you are objecting to an early disposal of the suit.
I filed my for super declaration of my right hand title for the said land bearing survey number.
It is your suit, this other suit number 17. Other suit number 17 of 2024, suit filed by your client. Yes. And you do not want early disposal of the suit.
On the very last occasion on December, they have filed an application under order 1, rule 20 of CPC, my lord, by for the addition of the parties, and 6 additional parties, like 6 parties have been added, my lord. The court submitted that, serve the copy, so as to they appear and to file a written statement, my lord. It was done in the earlier occasion on December. Now in January, they are filing a suit, like petition for early disposal of this case, my lord.
Sir, either you are opposing this prayer or you are agreeing with the prayer. There can't be a midway. How long have you practiced? In a year. So by now, at least this much you should be knowing.
Process of law is going.
Eshu, come, Stephen. No. You appear, do you know anything at all about the matter? He appears for whom? Defendant.
They need to file the written statement and then usually in started also. Things to be noted, the defendant in the text of pending, they are taken adjournments. They have taken 3-4 adjournments as mentioned in the annexure.
This civil revisional application has been taken out by the added defendants in OS number 17 of 2024. Stop. The only prayer made in the application is as follows. There's only one prayer, set it out. Paragraph. Learned advocate for the plaintiffs opposes the prayer. This is rather strange. Stop. All legal proceedings should be carried to their logical conclusion as expeditiously as possible. Stop. Paragraph. I see no reason to disallow the prayer made in this application. Stop. The application is allowed. There will be an order in terms of prayer, whatever, prayer I think, prayer Roman 1. Disposed of. Yes. Day after. Day after. What is it? Revision against what?
The pleadings are there that the land belongs to some of the portion of the land belongs to the government. And in the schedule of the property also, the said land was shown in the schedule of the property. Now, my lord, after 10 years, earlier they have taken an application under section 80 of the CPC and under Ordinance Rule 10 for addition of party. That was not pressed at that point of time in the year 2017. Now, again, they have taken out an application to array the government as a party and seeking an exemption under section 80 subclause 2. Now, my lord, the court allowed the application for addition of party to the government.
But dispensation not allowed.
Dispensation rejected. They are rejected, but directed them to serve a copy under section 80 to the government.
Come back day after tomorrow. Mr. Khan wants that. Opposition. There's no private respondent. But your actual relief is against the official respondents, authorities. This writ application has been filed, praying for inter alia the following relief. Just prayer one set out. Small I, just as it is here, please. Paragraph, learned advocate for the petitioner fairly states that there is no scope for passing any interim order. Stop. Affidavits may be directed to be exchanged. Paragraph. Let affidavit in opposition be filed within 2 weeks from date. Stop. Reply thereto, if any be filed within a week thereafter. Paragraph. List the matter after 3 weeks before the then available circuit bench, subject to its convenience. Paragraph. Since the private respondents are not represented today, learned advocate on record for the petitioner shall communicate this order to the private respondents.
Friday, after the period of 3 years, this is
So why Friday? Why not today? Why?
They already qualified exam, they have document time for that one, and after that, this point we get.
We'll show that on Monday.
Right.
Circuit will come towards an end. You don't want to do your matters, what to do? What is the Friday? Friday. Recorded order. On the request of learned advocate for the writ petitioners, let this matter stand adjourned and be listed again on give Friday's date. Service complete?
If not tender notice was for purchase of dustbin.
Purchase of
Dustbin. By the Kolkata municipal.
dustbin.
Dustbin. By the Kolkata municipal council. That only that supply order was issued and income of supply. was. Similarly, in the year 2010-11, the same process was initiated and the dustbin was supplied. Well, at that given point of time, I was holding the post of computer assistant under the Blair Municipal Council. And I was assigned with the job of accountant under the Blair Municipal Council. And he said process, the file was, when the file was muted, so far as the first tender is concerned, once a requisition was asked me as to the availability of the fund. This is the only part which I have played, I will show from the documents. This is the only part, whether what is the status of the fund available. I said this is the status of the fund. Second time, when the process was initiated, they have sent the comparative statement and asked me to see whether the figures are correct or not. It tally or not. Second time, I said tally. And subsequently, they have asked the fund for reset. And I said this is the amount thank you. All the documents are there. Now, after more than 14 years, in the year 2021, a so-called notice was issued to me saying that when the anti-corruption conducted an inquiry, it was found that the procedures were not followed by the PBMC. Procedure related to supply order, the initiation of the process of tender and the period after which the tender is to be accepted. These are not my part, but this was the allegation. And in that it was written that I was an assistant engineer, absolutely wrongly. I am not an engineer at all. So I replied, I said, I have got nothing to do with this. This is absolutely an abstract proceeding. They intend to initiate an AF. They waited for more than 3 years. On 1st August 2024 or 2025, my lord, a disciplinary proceeding was initiated. Now, my lord, I have challenged the said memorandum which was issued on the 2 grounds. First, on merit also there is no allegation against me. Secondly, my lord, there is an unexplained deal in initiating the disciplinary proceedings. Now, my lord, the Supreme Court in the latest judgment of Amrit Srivastava has categorically said there may be an occasion where the disciplinary proceeding was initiated subsequently and there was an explanation given by the authority. Then in that case it is permissible because the Supreme Court has considered both the aspects. There are 2 issues framed. Whether on merit you have to see the merit and if you have to see the unexplained delay. If there is an unexplained delay, you cannot pursue further bit because a right has been accrued in favor of the person. Now, my lord, here this is the exact case. Now, what happened, my lord? I was the accountant. One assistant engineer was, there were several other incumbents who all were there. They have given separate charge sheet to all of them. One of the incumbent approached before this court, the assistant engineer, similar charge. Only the date of charge in his case is 30th July, in my case is 1st August. Charges are same. He approached this court and I have argued for an interim order and this court has granted an interim order. Now, my lord, I have imposed it, my lord, and this court has considered page 105. My lord. Everything is same, my lord. Date instead of 13, it may be 14. Here, everything is same.
Yes, Mr. Kumar, similarly circumstanced. Yes, yes, but in the meantime, it's the same order as was passed. Come. The petitioner has challenged a memorandum of charge dated August 1, 2024, issued by the respondent authorities, initiating major penalty proceeding against him. Stop. One of the grounds of challenge is that the memorandum of charge has been issued after an undue and inordinate delay of about 16 years, for which there is no explanation. Paragraph. Learned advocate for the petitioner relies on the decision of the Honorable Supreme Court in the case of, you will find the name at page 106, Amresh Srivastava versus State of Madhya Pradesh, in civil appeal number such and such, delivered on April 1, 2025. In support of his contention, continue, no stop. In support of his contention that unexplained inordinate delay in initiating departmental proceedings, vitiates the entire proceedings. Paragraph. Learned advocate has also drawn my attention to an order dated September 2, 2025, passed by a coordinate bench in WPA 438 of 2025, within bracket Shri Zaki Ahmed versus the Honorable Lieutenant Governor and others. Stop. In that case, the petitioner is the executive engineer, bracket within bracket E and M, of the municipal council. Stop. The petitioner in that case is the executive engineer. Reframe it. The petitioner in that case is the executive engineer, E and M, of the municipal council. Stop. In almost identical facts, the coordinate bench granted an interim order staying the operation of the impugned memorandum of charge and directed exchange of affidavits. Paragraph. I am also of the view that the petitioner in this case has made out a prima facie case for interim order being passed. Stop. In the memorandum of charge, there is no explanation as to why the same has been issued after almost 17 years. Stop. Paragraph. There'll be a stay of operation of the memorandum of charge dated August 1, 2024. One second. That was not limited in point of time. Till today, this is February, no? February beginning. Till the end of March, 2026, or until further order, whichever is earlier. Paragraph. The respondents will be at liberty to file affidavit in opposition within 3 weeks from date. Stop. Reply thereto, if any, be filed within a week thereafter. Stop. Paragraph. Let the matter be listed before the list the matter after 4 weeks before the then available circuit bench, subject to its convenience.
On behalf of office. This is that item I'm not aware of. The appointment was stalled on the ground that the education department saying that all the inspections of governments are applicable.
Oh, yes, yes. Article 30. So argument is complete. Then I'll reserve the order. Argument, hearing is concluded, judgment is reserved. Patida. Patida.
Number 12. Second appeal, where there is a delay. I have searched the other side, I have filed a of service.
Delay has to be considered by the single ones. Yes. Delay of?
7 months.
I'm very liberal with delay. You are for all the respondent opposite parties. Very well. Huh? 296 days. So can 1 is the delay application. Take can 1. This is an application for condonation of delay of 296 bolle. 296 days in presenting a second appeal, comma, as noted by the stamp reporter. Stop. Paragraph causes shown being sufficient. The delay is condoned. Paragraph can 1 is disposed of. What is can 2? Oh, now before the revision bench, yes, for admission. Place the matter before the revision bench for admission of the second appeal. When, tell us. Give tomorrow's date.
Number 30.
Hey, take down. This is an application for restoration of WPA 276 of 2022, which was dismissed for default on January 28, 2026. Paragraph, having heard learned counsel for the parties, I am satisfied with the explanation furnished for absence of learned advocate for the writ petitioner on the day the writ petition was dismissed for default. Paragraph, accordingly, the order dated January 28, 2026, is recalled. Stop. WPA 276 of 2022 is restored to its original file and number. Paragraph can 2 of 2026 is disposed of. Paragraph, list WPA 276 of 2022 along with, yes, that's right, along with such and such. Tomorrow? Tomorrow. Oh, so which is the number? 314 or? দেখা একবার দেখা ওদের দেখিয়ে দাও না।
Item number 72. And for item number 72 already this.
So this matter, along with WPA 341 of 2022 tomorrow on such and such tomorrow.
I'm appearing for added respondent.
Item 40, WPA 485 of 143.
No, pray for not today.
Say, hearing that.
Then
It's there.
That it is hearing matter.
It's order that we have taken up along with the.
then let it be listed under the heading hearing,
Obliged.
both matters.
Item 16, detailed transfer of 2025.
Lord, I am for the alleged contempt.
Prashant, yes, for that additional, not to be.
First time. No, you're.
No, Lord, I appeared, I filed the affidavit in complaint, sir.
Not today.
Item number 17, WPSP 25.
I'm appearing for the added responsibility.
How many matters?
Oh, yes. So 45 ZA.
Section is given upon that day. Now the succession certificate has been duly obtained. This question would have been arisen in the initial stage. The succession certificate was not.
It is
obtained.
last order training. उसकी सही नहीं इसमें। ठीक है जी। Yes, sorry.
For section 45 ZA, he is correct, my learned brother is correct, that he is supposed to receive the amount.
Yes.
At the initial stage, when the deceased died, had he approached him, this question would have been arisen. But now, since I have obtained the succession certificate, that will prevail upon nominee.
What says this Bombay High Court says so?
There is a Supreme Court judgment,
Yes.
Ramchandra Talwar and others versus Devendra Kumar Talwar and others.
On this point.
Yes, on this 45 ZA.
Okay.
Yes. So now let me pass appropriate order. You have seen this judgment.
I am having that judgment, my lord.
Yeah.
My lord, I want to rely upon the one of the Supreme Court judgment. This judgment is related with GPF, but I want to rely on the ratio part of this judgment.
What is the year
Paragraph
of the
40.
judgment? Year of the judgment?
It's recent judgment, my lord. January 2026.
Has it considered 2010 Supreme Court cases?
Ramchandra Talwar.
Ramchandra Talwar?
My lord.
It's considered. Yes.
My lord, the relevant part is paragraph 14, my lord. The position has been very clearly stated, my lord. What is the position of nominee and how once amount has been given, received by the nominee shall be taken by the legal heirs by the way of succession certificate. Paragraph 14, my lord. Once amount has been received by the nominee, the person who is claiming by the dint of succession certificate shall approach the competent civil court to claim that.
Very well. This is, I'm exercising writ jurisdiction. So you received the money. I'll restrain you from utilizing the money for a month. For a month. In the meantime, if they can approach us, he's right. That is what the Supreme Court has said.
My lord.
So you approach the appropriate, I'm giving you time, I'm granting you interim protection. Approach the appropriate court.
My lord.
If they don't, do whatever you like with the money.
My lord.
Issue, come.
Succession certificate has already been obtained.
Yes, that has been decided.
On the basis of that, file a suit against him,
My
money suit. On the strength of that. Do it tomorrow, 2-page suit, nothing, 2-page plain. The petitioner is the wife of one Laik Ali, comma, since deceased. Stop. It appears that the deceased had deposited certain sums of money in a bank account that he opened in his name with the Punjab National Bank, comma, 144, comma, JN Road, comma, Gwalghor, comma, Port Blair branch. Stop. It further appears that he had made the respondent number 2 here, the added respondent herein, the nominee in respect of the said bank account. Stop. Paragraph. The said Laik Ali passed away on September 11, 2021. Stop. As on that date, comma, a sum of approximately rupees 22.08 lakh was lying in the concerned bank account. Stop. Paragraph. The petitioner, comma, the petitioner obtained succession certificate from the competent court and staked her claim to the money lying in the aforesaid bank account. Stop. The bank refused to accede to her request. Stop. Hence, the petitioner has approached this court. Paragraph. Pursuant to this court's order, comma, the nominee was added as a respondent. Stop. Paragraph. The learned advocate appearing for the added respondent relied on section 45-ZA of the Banking Regulation Act, 1949, ZA within bracket 2, which reads as follows. Last time what you gave it, just reproduce it. Stop. Paragraph. He says that under the aforesaid provision, comma, the Punjab National Bank is under a statutory mandate to hand over the monies lying in the aforesaid account to the nominee. Stop. Paragraph. Learned advocate for the petitioner relies on a decision of the Honorable Supreme Court in the case of this one, give the full name, and reported at 2010 10 SCC 671.
45ZA, Your Worship. It is in different context.
Let me see.
I relied upon the ratio of that judgment.
It can be because the Provident Fund Act is something different.
What did it say? Such and such. No. In particular, Learned Counsel relies on paragraph 5 of the reported judgment, which reads as follows. Set out paragraph 5. Paragraph. Per contra, comma, learned advocate for the added respondent refers to a decision of the Honorable Supreme Court rendered on January 7, 2026 in petition for special leave to appeal, bracket C, diary number 71438 of 2025. Marked it. Stop. In particular, reliance is placed on paragraphs 13 and 14 of the judgment, which read as follows. Paragraphs 13 and 14 set out. Paragraph. Although the decision in Paresh Chandra Mandal, Supra, does not discuss section 45ZA of the Banking Regulation Act, the ratio of the decision appears to be that the Provident Fund authorities would obtain full discharge by handing over the dues of a deceased to the nominee of the deceased. Stop. Reading this decision together with the decision cited by learned counsel for the petitioner, I am of the view that the appropriate course of action would be for the Punjab National Bank to hand over the monies lying in the concerned account to the added respondent herein. Stop. Let that be done within a week from date. Stop. The added respondent shall not deal with such monies for a period of 1 month. Why 1 month is not enough? Where is he? Where is she? Yes, that's all right. For a period of 6 weeks. For a period of 6 weeks from the date of receipt of the money from Punjab National Bank. Stop. In the meantime, the writ petitioner will be at liberty to approach the appropriate civil forum, staking her claim to the money received by the respondent number 2 as nominee of the deceased person. Stop. If deceased person, stop. That is all. What else? That is all. This is limited, 6 weeks limited. If they can get something, they'll get it. Paragraph WP is disposed of. Set out his here from.
I am grateful, my lord.
Oh, acha. Civil forum, appropriate civil forum, on the strength of the succession certificate that she has obtained in the meantime.
Item 18, WPS 304 of 525.
Ms. Das was appearing. Then pass over.
Item 19, WPS 345 of 525.
Item number 19 to 32, then 34 to 67.
Yes, Mr. Very short point.
Your Lordship, I am coming to that, Your Lordship.
Yes.
Your Lordship, regarding maintainability, Your Lordship, I have 2 things to submit.
Yes.
The first one is that I have challenged the entire action of the authority on the point of jurisdiction. This is my first point. Whirlpool case supports me. It's jurisdiction. And I have judgments in line with exactly the same issue. And the writ petition was entertained and the entire act of the authorities relating to assessment was set aside. It is the first thing. The second thing is that, Your Lordship, they are asking me to go to the appellate forum. Where are the rules? Rules have not been framed yet. After filing the writ petition, hurriedly they just appointed a joint civil justice senior division to be the appellate forum. Rules are not there. As per the act, rules are mandatory.
They appointed.
They appointed authorities.
With the consult of Chief Justice of India, it has been.
They have appointed. After filing the writ petition, in order to frustrate my writ petition, they appointed the appellate forum, no doubt.
Why
But
will your
who
writ petition-
say,
Why will your writ petition be frustrated? Go there, argue
no,
there.
Your Lordship, unless and until rules are there, where I will file, how I will deposit, how the summon will be issued, kindly see. It says, section 6,
What?
Your Lordship, it is of the regulation. Page 77 of the writ petition. Regulation 73, subsection 6. The method is prescribed. Subject to the previous sanction of the government, the appellate tribunal shall, for the purpose of regulating its procedure and disposal of its business, make regulation consistent with the provisions and rules made thereunder. Thereafter may be seen. The regulations made under subsection 6 shall be published in the official gazette. These things have not been done. The word shall is used. Subject to the previous sanction of the government, the appellate tribunal shall. Now that has not been done till today.
Yes, so this is one.
And in the official gazette, it has to be published also. Because rules will be there, then only, Your Lordship, I can file. Your Lordship would remember that when Benami Transaction Act was enacted, for decades, Your Lordship, that act could not be implemented because rules were not framed. Because how Your Lordship will file the case and how the appeal will be entertained, court fees, all those things will be there. Many things are there. Now, Your Lordship, I am giving one example. This is the value-added tax appellate tribunal regulation, which has been framed by the Andhra Pradesh. I'm giving one example. There, Your Lordship, may kindly see how the procedure has been laid down. After the appellate tribunal was formed, this regulation was made by the appellate tribunal for the purpose of its procedure and all those things. This is not a...
What do you say, Mr. Kumar?
No, with regard to, Your Lordship, once Your Lordship is satisfied with this, that aspect, I will go deep into the merit. Or else, Your Lordship, if Your Lordship is not satisfied, then with regard to the authority of the jurisdiction point, Your Lordship, that also I will make submission. Let him satisfy this aspect itself.
Jurisdiction of the writ court.
Assessing authority.
I see.
Lord, with regard to these, they say there are no rules how to file, where to file, what are the modus operandi it has to be processed. But the rules which is clearly given 55A, 55B and 55C are the rules, my lord, which has been clearly given.
Of what? 55, 56?
The, my lord, the regulation of VAT rules, because this is a regulation 2017, that is VAT rules 2020, my lord.
Which one you are showing?
Rules.
The VAT rules.
VAT rules.
That is in respect of the VAT regulation, not in respect of the...
Lord, and subsequent to that, my lord, the
insufficient.
55A, not 55A, 55B and 55C. ma'am.
Yes.
Lord, I don't know why they are apprehending. They are
No,
taking.
no,
Lord,
I'm not
let me.
apprehending.
I not.
This
disturb my
55A, 55B
Lord,
and all these things, these are not sufficient, Your Lordship. If Your Lordship would see the tribunal's regulation which has been framed by the Andhra Pradesh, Your Lordship.
Forget Andhra Pradesh. You said there's nothing.
Your Lordship, kindly go through, Your Lordship, once. Your Lordship will find the answer.
My lord, the regulation itself says, my lord, they have participated in a proceeding under section 34. And when an order has been passed, the remedy is live before the appellate authority. Their only contention was while filing the writ petition saying that there was no appellate authority, so we approached the writ court. So not the writ court but says the writ court is ceasing with the matter and protected them. Now, my lord, there is a tribunal. What harm? My lord, they can raise the point of jurisdiction, whatever question before the tribunal.
Free deposit, free deposit,
That is the question, my lord. They don't want to do it.
free deposit.
Your Lordship, I will make all submission, Your Lordship, because Your Lordship may kindly give me time.
It is an
Because
appellate
this is-
authority dismissed.
Very well, you take your seat. Yes, make your submission.
Your Lordship, first of all, Your Lordship, 55A and 55B, then 55C. These are all procedure with regard to the filing of the appeal and hearing of the appeal. The court's procedure, which is to be prescribed, that is not there. How the summon will be issued, what would be the format of the notice, all these things are not there in the regulation. And then where the security deposit has to be made, all these things are not there in this regulation. That will be in the procedure which is prescribed. Apart from that, Your Lordship,
Yes, yes.
even form, Your Lordship, the form furnishing of security, the form is nil. Because that is to be prescribed under the rules which will be framed by the appellate tribunal.
Rule 23.
Yes, Rule 23 and that was. This is with regard to forfeiture of security.
Rule 20. 21.
Yes, Your Lordship.
Chapter 5. Entire
five.
chapter 5 on security.
Person and required amount of security to be furnished. This is in respect of the commissioner, before the commissioner, how it is to be done. Entire thing is with regard to the commissioner, not the appellate tribunal.
That applies to the appellate proceeding also. That's what I'm saying.
Your Lordship, then Your Lordship, so far as the jurisdiction point is concerned, I may be permitted to make submission. Your Lordship, my junior will make submission. with regard-
Jurisdiction, you can also argue before them.
No, Your Lordship, when it touches the root, Your Lordship,
Yes.
that is the authority has no
Show me-
power itself.
Show me a decision.
Yes,
Which says the writ court must entertain a writ petition.
the case, Your Lordship, apt to this particular point, the writ court has entertained despite the availability of appellate forum.
It's not. Availability of an alternative remedy is never a bar. Writ court's jurisdiction cannot be barred by anything.
Your Lordship,
No statute.
I admit, Your Lordship, but
Why should the writ court exercise its jurisdiction when there is an alternative efficacious remedy?
Your Lordship, I explain, Your Lordship, the reason why the writ court generally entertains that type of writ petitions. The reason is that, Your Lordship, in my case, especially in my case, if some authority is passing an order which is without jurisdiction, the problem is that, Your Lordship, if I have to go to the appellate authority, I have to deposit security. I'm coming to that. If I'm able to satisfy this honorable court that it is without jurisdiction, why should I deposit a security? Why should I make security deposit? Kindly note this point, Your Lordship. Suppose there is no question of depositing the security.
Show me how it's without jurisdiction.
Yes, Your Lordship, my junior may be permitted to make submission.
Are all these cases, do they involve the same point?
Same point.
Yes.
Lordship, I'm submitting a compendium of judgments, Sir Lordship,
Yes,
which I will be referring during the course of my submissions.
on the same point. Please
They're all on the
please
same
don't multiply.
Your Lordship,
If one judgment suffices, just then
Your Lordship.
stick to that. Yes,
So first and foremost, Your Lordship, this regulation was framed in the year 2020. When the regulation was brought into force, the value added tax regulation, prior to that, there was octroi bylaws. But when the GST Act was enacted, the octroi bylaws was forded with, and the value added tax regulation came into force. Now, what happened after the value added tax regulation came into force? Rules were not framed until the year 2020. So, from 2017 till 2020, the SECs were made to pay the required tax, and it is not disputed that the SECs have not paid the tax. What they are disputing is the manner and form in which they wanted us to pay the tax that we have not complied with. And that too, they are themselves unclear as to in which manner we have not clarified with regard to the filing of returns. Now, Your Lordship, 2 points in which I would satisfy this honorable court whether this particular writ petition is amenable to writ jurisdiction or not. First is, Your Lordship, there is limitation. What happened when an assessment is being assessed by the VAT commissioner? That power of assessment is subject to a limitation period. What happened in 2017 when the regulation was introduced? Till 2020, there were no rules framed. In 2021, out of all a sudden, the commissioner brings an order stating that as the rules have been framed in 2020, so for the period 2017-18 till 2019-20, comply with the rules retrospectively. Now, whether the commissioner has such power to pass an order, first I would like to state with regard to that. This is the first point where the commissioner has exceeded the jurisdiction.
Sir, first show me what you are challenging in this
Your Lordship,
petition.
Your Lordship. Your Lordship,
Notice of assessment
notice
of tax
assessment of tax due
and penalty.
and penalty. After this, Your Lordship, I submitted objection. As per the regulation, I appeared before the commissioner. I submitted my objection. Hearing was done. My objection was rejected. So, along with these two notices, the rejection order is also the order under challenge.
Where is this 30th January order? Which page?
Your Lordship. Page number 156 of my writ petition. This is the order passed by the value added tax commissioner after hearing my objection.
156.
156, annexure P9.
Or is this the notice?
This is the order, Your Lordship. 157 it begins. From 157 it begins. 156 is the notice, 157 is the order.
No, I wanted to, because your prayer A, in prayer A, you have challenged the notice of
The
assessment.
notice, the notice.
Where is that?
Your Lordship. The notice of assessment is page number 36.
The date doesn't tally. The date of page 36 is 31st of December 24.
Yes, Your Lordship.
And look at your prayer A.
That is the final order, Your Lordship. 22/7/2025 is the order with regard to my hearing of.
Prayer A, sir.
Yes, Your Lordship. 22/7/2025.
Prayer A of your writ petition.
Prayer A. Your Lordship, there's a typographical mistake. Notice भी है, final order भी है, notice भी है.
Come back after lunch. I'll rise, I'll come back after lunch.
Your Lordship.
Have you followed what I'm trying to?
Yes, Your Lordship. Yes, Your Lordship.
I think there is a typing mistake. I think.
Tell me that, tell
Yes,
me
sir.
that.
Because we are finding it like that.
I'll come back around 2 o'clock.
कम से कम वो वाला देना था जो वाला मुझे नहीं
matters can be released for the day. Release.
Some notices have the date of the agent. So by mistake, we not clear that date.
So here, what will it be? I see. And that is at page? So this is a notice of demand. Notice of tax deed. You have challenged this and you have. Right.
Subsequent notices, when I had submitted the objection before the competent authority, my objection was heard and the said objection was rejected. The regulation describes that at the first instance, I have to go directly back to the commissioner and file an objection. The commissioner will conduct a hearing.
Where is that?
Page number 157, last mention weekend.
Yes, very well. Now you can continue in your own way. Yes.
There are 4 financial years which are considered in this.
Yes.
17, 18, 19, 19, 20, and 2021. And the assessment has taken place on 31st December 2027. The notice of assessment, 31st December 2020. Now, Your Worship, kindly come to page number 58. That is section 34 of the regulation. Page number 58 of the regulation.
One second. $54. 58. These are the regulations of 2017.
No assessment or reassessment shall be made by the commissioner after the expiry of 4 years from the end of the year comprising of one or more tax periods for which the person permitted. That means the limitation period described is 4 years from the end of that particular financial year. Now, kindly come back to the notice of assessment. The date of assessment is 31/12/2024. Automatically, financial year 17, 18, 19, and 19, 20 becomes time. Because for 1920, the end will be 31st March 2020 for financial year 19. So the commissioner ought to have issued the notice by 31st March 2024. So the commissioner hearing has exceeded the jurisdiction conferred upon him by making this assessment. By acting beyond the period of. Now, Your Lordship, from the compendium of my judgments. First is in the compendium of my judgments, page number 126.
2021 is within limitation.
2021. That also I have certain sum. First, I will satisfy with regard to these three financial years.
Yes.
From the compendium of my judgments which I have submitted, page number 126.
Yes.
Judgment of the Honorable Supreme Court in case of Tata Trade Services. Limitation on reassessment. Competent authority must address preliminary objections regarding limitation. Division bench view that statutory remedy of appeal must be pursued, disagreed with. Single judge decision to address the issue of on limitation. There also there was a similar issue which was brought up, where the question of limitation was on the Honorable Court. And when the question of limitation comes and the subordinate authority acts beyond the period of limitation, that means it acts beyond the jurisdiction conferred upon. And on doing so, then if it is challenged, the player automatically becomes ineligible. Here, Your Lordship. Now I would like to raise another judgment, page number 59. Page number 69. That judgment begins with page number 28. It is a judgment of the division bench of the Bombay Court. And this particular judgment, Your Lordship, particularly exactly deals with the similar.
Page 60
Page 69 is the relevant. 69
starts at
page number 29. Starts at 29. Go to 28. 28 it starts with, and the relevant portion 16.
yes.
The relevant paragraph is 69, paragraph 15. We have already read the improved notices dated 25/9/2020 to be barred by limitation, and consequently the orders of audit dated 12/10/2020 and 13/10/2020 are also time bound. It is a settled position of law that question of limitation involves question of jurisdiction. A plea of limitation is a plea of law which concerns the jurisdiction of the court trying the proceeding. Consequently, when an improved notice or an improved order is meant to be beyond limitation, needless to say, it becomes a notice or an order which is without jurisdiction. After this, the working case was considered, and the conclusion was page number 71, para 61, the concluding part. In the present case, we have already arrived at the conclusion that the improved orders of audit were passed in violation of principles of national justice. We have also arrived at the conclusion that the improved notices and the consequential orders of audit are barred by limitation and thus without good jurisdiction. In such circumstances, question of delegating the petitioner to the appellate committee simply does not.
All right.
Similar notion was taken by your lordship in the case of Calcutta Municipal Corporation, page number 7. Page number 72.
Yes.
Here also, the lordship had mentioned that principles of order and pattern were not complied with, and that is completely my next point of submission. And here also there was an appellate remedy that was existed, and your lordship had quoted the verbal case and allowed the immediately next to that, page number 100, page number 100. This is also a division bench of the Calcutta High Court, wherein your lordship had pronounced the judgment, upholding the order of the learned single judge.
Page, sorry, page.
It starts with page 100. Relevant portion is page 140.
Hundred 14.
Here also the issue was that the KMC Act, the Calcutta Municipal Corporation Acts, mentions that there is an appellate authority, but in page number 140, your lordship had pronounced that learned single judge is also very much aligned to the message that when order under section 188 of the KMC Act, the applicant is subject to the respondent written petition and the consequences of being cannot fix with respect to a problem, and in that even the rule of law would require an express of natural justice. There appears to be no error committed by learned single judge in following the disposition as above, and also the ratio laid down in the verbal population versus registrar of the parts by reported in 1998 by the Honorable Court. The next page is the relevant procedure lordship. Therefore, it is the tried law that the proposition of appeal being available under the statute shall not deter the agreed person to approach a court of appeal in case in the following the procedures under the law of the state authority defines or fails to comply with the principles of natural justice, as that though may not affect the procedure to be available, but shall be defined by the rule of law.
All right. Then
Now, with regard to financial year 17, 18, 19, and 1920, I have experienced that these three financial years are
limitation, and also natural justice, you say. That will apply to all 4 years.
one more very important thing that will apply to the financial year 2020-21. Again, page number 26, that is the power of the commission at this. Also the relevant section is at page number 58 of my petition.
Hmm.
Section 32 confers power upon the commissioner to assess on default payment of tax. Now, if any person, 4 conditions are given, if the particular necessity does not satisfy, then the commissioner may, for reasons to be recorded in writing, assess or reassess to the best of his judgment the amount of net tax due for a tax period or more than one tax period by a single order, so long as such tax periods are comprised in 1 year. This means that in particular order of an assessment, n number of tax periods can be considered, so long as it comprises one particular year. Now, the impugned notice comprises 4 financial years. Here also the commissioner has exceeded the jurisdiction. The assessment with regard to financial year 2020-2021 could not have been done along with the other 3 financial years. It ought to have been done separately. Now, your lordship, this notice may be read. Lordship, it is mentioned, whereas I am satisfied that the dealer has not furnished returns. Page number 36, lordship. Yeah, please. Whereas I am satisfied that the dealer has not furnished returns, furnished incomplete returns, or incorrect returns, furnished a return that does not comply with the requirements of federal and Nicobar Bank tax, any other. Now, your lordship, what is the fault of the SSC? The section 32 has been just reproduced here. They themselves don't know what is the fault. And whatever faults can be attributed to, every fault has been mentioned as an option. Now, your lordship, very accurately. Turnover reported, turnover assessed. Both are same. Tax reported, tax assessed. In all other financial years, it is the same. In one financial year, 17-18, it has been mentioned that there has to be more tax to be paid. That means tax assessed is more than the tax reported. But what is the calculation?
17-18.
What lordship sees? Turnover reported by the leader, turnover assessed is the same.
Yes.
Tax reported and tax assessed differs, for which they have subtracted the tax assessed from the tax reported, and an amount has been arrived into as a calculation.
Yes.
Now, your lordship, as to how this calculation was brought into action has not been explained anywhere. Now, this particular point, that calculation has not been explained, and without explaining the calculation, if the department comes into a conclusion that there has been a due, your lordship has discussed the same thing in the case of Calcutta Municipal Corporation, where your lordship has quashed the notice of assessment on that particular ground. So, now, your lordship, next one. This is a notice of assessment under section 20, which the authority claims to be conducting on best judgment assessment, the best of them. Now, your lordship, the regulation came in 2017, rules were claimed in 20. Now, the main thing, when an SSC goes and files a tax return, whether that tax return has to be filed monthly, or they be annually or half yearly, that depends on the tax bill. Now, your lordship, the regulation, definition of tax period, that the regulation came, section 2ZG. It states that tax period means the period defined in the rules. That means from 2017 till 2020, there was no definition for tax period. And 2020, the tax period was defined, it has to be monthly. But the returns has to be filed quarterly. Now, the authorities in their affidavit in opposition are acting upon one particular order of the Commissioner of Bank. Order dated 7 January 2021. In this order, because the said that AO is not paginated, so I'm just mentioning the date. That in opposition is that the format that is not paginated by the elections.
You're right. Yes.
The order dated 7 January 2025.
How will that one find that out? তুমি কি করে পাবে? Yes.
The main question of dispute is, I did not find the tax returns in the date prescribed by them and in the manner and form prescribed. So the manner and form came to be clear only after the rules were framed, because neither the tax period was defined, nor the form in which I have to file the returns was brought into action. So till 2020, I filed the returns in the form in which I used to do earlier when octroi bylaws were introduced. So similarly, the SSC filed the returns. Now, to this order, what the commissioner did is, on promulgation of Andaman and Nicobar value-added tax rules, and in pursuance to this office press release dated 31st December 2020, all the registered dealers under Andaman and Nicobar value tax regulation are hereby directed to submit their quarterly returns from the period of second quarter 2017 to third quarter 2021 in prescribed format by 28 March 2021. Now, the commissioner passed an order changing the date in which return has to be filed and making this order be retrospectively applicable to the SSC. Now, whether the commissioner has got the power on jurisdiction to pass an order of such kind, Lordship, page number 76 of my report. Page number 76. The relevant section item. The Lordship, page number 76. The relevant section is section 70, subsection 5. There is a Lordship. Every notification issued by the commissioner under this regulation shall be published in official gazette and shall not have any effect prior to such publication. The regulation bars retrospective effect and the particular.
That, sir, it may have two meanings. One is, it doesn't talk about retrospectivity at all. What it says, without publication, no effect. Now, effect only upon publication. Now, effect from which date doesn't say. Possible argument is that if at all the commissioner has the authority to issue directions with retrospective effect, then that will also take effect only upon publication. Oh, it has never been published.
7 January 2021 may be seen, the order. That is an order. So from where did that commissioner got power to pass an order is nowhere clear in the regulation. The commissioner ought to have properly followed the regulation and through an official gazette notification, ask the SSCs to file the returns in as per that format and with regard to that particular day. Because the period also the authorities changed without any gazette notification.
I'm just wondering on a different point, on the point of natural justice, sir. These two notices, notice of demand and notice of penalty, were issued without affording you an opportunity of hearing, right? But you did file an objection to these two notices, and then a hearing was held. So would that not be sufficient? It's not that you did not get an opportunity of disputing the amounts. Would that not be sufficient compliance with the principles of natural justice?
When I had filed the objection, I had raised the point during the course of hearing with regard to that principle of natural justice has not been complied with without issuing particular notices. I have not been heard. But what the order says, Your Lordship, they say that you are not required to kindly put the Your Lordship to look into the after my objection was heard, the order that is passed by the authority.
Say the authority that issued the notice and the authority which heard you is the same. No.
What happened? This was issued by one particular commissioner, but the regulation says it has to be placed before the same commissioner. That commissioner got transferred somewhere. Now, when I submitted my objection before the relevant commissioner, that commissioner delegated authority to one joint commissioner. That joint commissioner heard my objection. And in that particular objection, when I raised that before doing that assessment, I was not given the opportunity of hearing what the commissioner has ordered. Then the petitioner contended that no notice was issued prior to assessment, as mandated under the regulation by making the reference to the judgment of Calcutta High Court in Shrimasa. In the instant case, it was observed that the notice requiring production of books and accounts was served upon the petitioner before claiming of the assessment. However, the same is neither mandated in the regulation nor the rules. Here, stating it's not required, but the rules required. There is a whole process that
Which is it?
Page number 7. Page number 70, section 15. It says that, Your Lordship, when the commissioner is about to conduct an assessment, we are stating that come and serve the accounts books will not suffice. Audit is mandatory. Why audit is mandatory, Your Lordship? Section 58. The commissioner is serve on any person in the prescribed manner notice informing him that audit of his business affairs shall be performed and when applicable, that an assessment already conducted under this regulation may be reopened. The new assessment or for the reopening of the assessment, an audit has to be conducted. Now, Your Lordship, section 58, subsection 4, very important, Your Lordship. The commissioner shall, after considering the return, he considered my return, the evidence furnished with the returns, no evidence was even considered. Either I was asked to produce any, if any, the evidence acquired in the course of audit. This is very important. Only after conducting this audit, now being ABC, subsection 2, serve a notice of assessment or reassessment of the amount of tax, interest and penalty, if any, pursuant to section 32 and 23. This means that if the commissioner is about to serve a notice of assessment under section 22 and section 23, that means prior to making that assessment, the commissioner ought to have conducted an audit. And that principle of conducting an audit is the natural justice audit item pattern wherein I get an opportunity to place my evidence. Because what has happened, though the commissioner will state that a prior notice was issued asking for the documents. But when the commissioner carries out the assessment to the best of his judgment, how does the commissioner do? The commissioner asks his authorities produced by returns, and on the basis of best of his judgment, he carries out the assessment. Now, if you consider that documents that are in my returns that have with respect to that documents, I ought to have been given an opportunity of clearing. Because now this is the form. This is the form which describes about the audit. It is the part of the rules. This is the form of audit. Now, Your Lordship, in this form, the second paragraph, when it starts from please take note that in the event of your failure to comply with this notice, the audit of the business affairs for the instant period would be made to the best of my judgment. Only when I fail to comply with this audit, whether there was any auditing done, there was no auditing. The commissioner, to the best of his judgment, that to violating the period of limitation, conducted an assessment. Now, whether this section would create this linked section or not, that is discussed in the case of notified by the division bench of court. Your Lordship, this is a union territory. Similar value-added tax regulation and rules applying double and human rather than double. So there, the Bombay High Court discussed the question whether section 58 of the regulation has to be read as standalone or together with 31. Your Lordship, relevant paragraph is page number 65. Page number 65. And is page number 65 of my compendium of the books.
Yes.
Page number 65, the relevant page of the paragraph 0.5.
Yes.
And it is that having regard to the meaning of the word audit as is ordinarily understood, since it is not defined expression under the VAT regulations, and having regard to the scheme of section 15, it is quite evident that when a notice is issued to a person informing him that an audit of this affairs of this business shall be conducted, the same certainly has a legal significance. Such a notice of audit may lead to assessment if not done, and if assessment had not been done, then either confirms the assessment or to make the reassessment if the result of the audit shows that despite the assessment already made, there is tax deficiency and no tax is required to be paid. If that is the position, then for making of assessment or reassessment, we will have to fall back upon section 31 and 32, for which the limitation of 4 years is prescribed in section 34. Therefore, section 58 of the bank regulations cannot be construed or interpreted in isolation or as a standalone provision. Having regard to the consequences for the implementation of section 58 has to be read with section 50. Now, your lordship, this 58 was mandatory to have done. And until unless the audit is conducted and the notice of audit has not been served, the commissioner has no authority to apply best of his judgment. The commissioner has right, but only after serving the notice of audit and me not complying with that notice of audit, the commissioner can go with judgment on best of his assessment to assess the tax. Now, your lordship, this same concept was held in one of the division bench of the Calcutta, wherein what happened, the appellate authority therein rejected the notices, watched the notices, and asked the authority back to reconsider. Here, the authority, the petitioner upon whom the judgment was delivered in favor, again challenged before the division. On the point that when, even though the notices have been watched, there is no point in reassessing. Your lordship, I will place that judgment from the compendium, page number 26. Dharna Saha case, your lordship. Very relevant to this particular case. Joint Commissioner Dharna Saha versus Joint Commissioner of Sales Tax. Division bench of this high court. The place in option. The writ petition has been filed challenging the order passed by the West Bengal Taxation Department, an application filed by the petitioner being dated so and so. At the first judge, the court was very curious to find out as to why the petitioner has challenged the order passed by the learned tribunal, as the learned tribunal has accepted the case of the petitioner and held that no notice was served on the petitioner before the assessment proceeding was completed. But in the last paragraph of the improved order, the learned tribunal has directed the assessing officer to initiate a fresh proceeding after sending fresh notice and complete the assessment within a period of 6 months. Agreed by this portion of the order, the petitioner is filed a writ. We have got the learned advocates appearing for the parties. The order in direction issued by the learned tribunal is not legally tenable in the light of the relevant statutory provision under the West Bengal Vanity Tax Act. Section 46(1) of the said act, read with rule this, states that authority should proceed to assess only after serving mandatory notice in form 25. Here also there is a different form, but there is a procedure allowing the prescribed minimum time to the assessee to comply with the prescribed requirements. Without service, no jurisdiction to assess may be lawfully assumed. This condition has not been satisfied in the instant case. The assessment becomes lawless in the eye of law. When the assessment itself becomes lawless in the eye of law and the period of limitation has already expired, now the commissioner cannot again reopen the assessment. Now, your lordship, with regard to notice under section 32, point of limitation, point whether all the taxation years can be combined into one notice or not, up to the section 58 auditing has been satisfied or not, all these are now, your lordship, next notice under section. This is very important. Now, on the basis of best of his judgment, commissioner made an assessment, and best of his judgment only, the commissioner find out that I am liable for certain penalty, and without assigning any reason, for every quarter, your lordship, page number 36, let me see. For every quarter, 22,000, 22,000, 22,000, and one for one particular quarter, 4,01,000. How did the commissioner arrive into this particular calculation is very astonishing, your lordship, because no reason has been assigned. Page number 36, this is the notice wherein I was asked to submit this much amount of penalty. Now, your lordship, the notice may be read. Whereas I am satisfied that the dealer has a liability to pay penalty under section 92 and 94 of the Andaman and Nicobar Value Tax Regulations 2017 for the following reasons. Failure to furnish quarterly return with the prescribed due date from 17/18 to 2020. But from how come the commissioner came to a conclusion that I have not served the particular return within the due date? Now, your lordship, the power of the commissioner to impose penalty may be looked to. Power of the commissioner to impose penalty. Page number 3. Page number 58 of the report.
Yes.
Section 33, confers power upon the commissioner to issue, to others and issue the notice of penalty.
Yes.
That the commissioner had reason to believe that a liability to pay penalty under this regulation has arisen. The commissioner, after recording the reason in writing, shall make and serve on the person a notice of assessment of that is received under this regulation. There is the reason to believe. There is the reason in writing. There is the explanation for the reason for which I have been imposed with such a huge amount of penalty.
Yes.
Not a much. The penalty has been imposed as stated in the notice under section 93 and 94 of the regulation. Section 92 prescribes maximum fine as 25,000 rupees and section 94 per quarter. I'm talking about per quarter fine. Section 94 prescribes maximum fine of 5,000 rupees. And if the whole section 94, page number 18, the whole section 94 talks about various offences on which other penalties can be issued, imposed upon. But none of the particular provisions in this section mentions about penalty for default in pay. And the max, if I have gone through the whole section, the maximum penalty is 50,000 rupees, that too in subsection 7. Subsection 7. Where a person who is not authorized under this regulation to issue a tax invoice has issued tax invoice percent, whatever it be, because they have relied upon section 94 to impose penalty, the maximum penalty under subsection 7 is 50,000 rupees. Now, in the improved notice of assessment of penalty, the lordship received for January to March quarter, for one quarter the penalty is 4,01,591. Then also the commissioner exceeded jurisdiction. Commissioner went beyond the regulation by imposing an amount of penalty which is not even there in the regulation. Now, what prompted the commissioner to issue such notice of penalty? The commissioner ought to have carried out an audit. The commissioner did all these through best of his judgment. Now, whether a commissioner acting on the best judgment analysis can issue notice of penalty or not, that has been discussed in 2 cases. The first case page number 18. Page number 14, it begins with, this is the judgment of the Allahabad High Court in Durga Steel Rolling Mills case. Page number 14 is the relevant portion. Page number 4. Judgment begins from page number 1. The relevant portion is at page number 20. Page number 14, paragraph 42. As already indicated above, the order of penalty passed under section this from the Act is based on the order of existing authority as passed under section 28 of the Act 2008. The assessment order under section this is on the basis of well-grounded estimate or reasonable guess as held by the Honorable Supreme Court, meaning hereby that the said order does not indicate the willful attempt to defeat or circumvent the tax law or to reduce the tax liability. Once the sign for non-imposition of penalties, negation of payment of tax, and for engagement there has to be willful act. Consequently, the court will examine as to whether there has been willful act on the part of negation in negation of tax. So this is the ground in which a commissioner can go through best of his judgment and impose penalty when there is tax evasion.
Now, relevant page number 80. A question of law was framed by Allahabad High Court. Relevant page number 18. Paragraph 49. The second question which was framed, whether the penalty under this section of the Act can be imposed where the assessment is made on the basis of best judgment assessment. The answer is no. Because when the commissioner is assessing to best of his judgment, to his own consciousness, the commissioner, without awarding an opportunity of hearing, cannot impose such an amount of penalty. Similar notion has been taken by the Madras High Court of Appeal. The relevant page is page number 23. The judgment starts from page number 20, the NS Sayar cars versus Appellate Deputy Commissioner. Page number 23 is the relevant portion. Paragraph 10.
Page number?
Page number 20. Paragraph. The mere fact that the assessment was made to the best of the judgment of the authority would not be sufficient for imposition of penalty, as the degree of proof required for imposition of penalty is quite different from and much higher than that required for the purpose of bringing the best judgment. And the other relevant things that we discussed, and the notices that fall in this. Now the question. After my objection being submitted and met with very the order that has been asked. And what first and foremost, with regard to
লোডশেডিং হলো নতুন করে শুরু হলো Yes.
page number 1, 7, 137. The order paragraph 1 in bold describes about considers about the aspect of limitation. The next page will be seen, Russian 158. Quite astonishing, Your Lordship, that the commissioner has created a new limitation for himself. The paragraph just about the retrospective activity. Page number 158.
Take your seat. Allow me to go through this. This is the most important piece. Yes. Oh, we released all matters. You didn't hear that? No, all matters would include Passover matters. We didn't make any exception there. Yes.
And on the aspect of limitation, the commissioner ordered that consonant with the principle that limits should not be triggered in the absence of the national level mechanism. They themselves have been demonstrated or to create the tax. It is both logical and legally sustainable to hold that the people usually comments only are where does this get from where does the commissioner is getting the authority change the period of limitation going beyond the statutory framework? And repeatedly, the commissioner in this improved order has relied upon an order passed by the commissioner itself on 7/1/2021. The order which I have already submitted upon 7 January 2021, that was not an official, that was not a notification, but of the official gazette. The commissioner has to pass an order requiring the SSC to act in certain terms. That order must comply with section 72 of the regulation, which means that that particular order has to be in the form of a notification published in the official gazette. And now, the commissioner passed that particular order of 1/7/1 requiring the SSC to reduce speed.
Would it be acceptable to you to go back to the commissioner, start from zero, everything being set aside, so that after hearing you, after affording you an opportunity of producing your books of accounts, whatever, a fresh assessment is arrived at? I asked you a simple question. Would this
Is that the practical reconciled. Now, this period, which of which the assessment has been carried out is 17. Now, the books and accounts of 2017 and going back to and of such a long period, just long back, it's very difficult for the SSC to have that particular books of accounts handled. Because at that particular point of time, there was no regulatory framework to digitally submit. Now they have brought it, submit everything digitally. And it is very easy for the SSC to submit everything digitally. All the books and accounts have been submitted digitally. But at that particular point of time, it was submitted manually. Hard copies were submitted. Now, if the commissioner gets an opportunity to reopen the assessment, that would beyond the period of limitation, it would be injustice to the system. Because it is not disputed that the SSC has not paid tax. Nowhere the commissioner has stated that the SSC has not paid tax. They have stated that we have not paid tax in the manner and form they wanted. And of course, it is impossible because the rules came in 2020. How can the SSC be expected to see something which has not come itself at that particular point of time? And the order requiring the SSC to retrospectively act in 2021 by submitting the 2017-18 returns in the new format, it's itself invalid because it is not a notification. How can the commissioner get that authority to pass such an order?
An erroneous order is not necessarily an order without jurisdiction. Right? Now, you have your entire effort has been to persuade me that the order of the commissioner, after hearing your objection, or the notice of demand and the notice of penalty, they are all without jurisdiction. Till now, I am not so convinced, let me tell you very frankly. They may be erroneous orders, they may be illegal orders. That an illegal or erroneous order is one and an order without jurisdiction is something else. Unless you can impress upon me it is without jurisdiction and therefore you come within the exception carved out in Whirlpool, I will not entertain your petition and send you to the appellate forum. Right. Till now you have told me about limitation, clubbing of claims, of assessments. Yes, natural justice. Natural justice is one area where if you can impress upon me that it was imperative, either because the regulations say so, or even if the regulations are silent, it has to be read into the regulations. Like the courts have said in many statutes, the statute may not spell out the requirement of complying with the provisions of the principles of natural justice. But the courts have said, no, since it has civil consequences for a citizen, a hearing has to be given, an opportunity of hearing has to be given before an order is passed. Apart from that, I do not see any. Your best point is natural justice, sir. You have been arguing very well, make no mistake. And therefore, I have been listening without interrupting you in any manner. Your best point is natural justice. Develop that point. Come back tomorrow again. Hmm? Yes, sir.
Let's say that, yeah.
What about natural justice?
You already filed an objection before the commissioner, and it has to be heard. The court has directed that court and appear before the commissioner. He has heard that, he has given opportunity of hearing, and he passed the file.
So therefore, now only the commissioner's final order is under challenge.
There has to be
Correct. I've seen that. I've seen that. Now, what happens is that if I set aside the commissioner's order on the ground without going into the merits, without going on any other point, breach of natural justice, what happens? It's not binding on me. The Bombay High Court judgment is not binding on me. But yeah, it says it's a question of jurisdiction. Where you showed it to me today.
Page number 126.
126. 126, yes.
Page number 127.
No. Bordering on jurisdiction. Very well. Even assuming on both ground of jurisdiction and natural justice, I set aside. Your junior is saying no fresh proceeding can be initiated. Limitation period. Yes.
Judgment
Yes, surely. Chief Justice Shivagyanam, that one. No, Chief Justice Shivagyanam's judgment.
Assessment of on self-assessment. Your self-assessment. In the display, it's a pattern. It's hard to get what you assess. Is it easy to first your self-assessment will be not key. When the regulation stops, stop the self. But the section 14 says, but suppose I say, but stocks, materials, the purchase, the details, deals from 2016. The purchaser dealer after first day of 2016 take into consideration. But the regulation says that the regulation comes to a audit. Think that regulation will impact upon the most tax regulation. That's how it is. But 16, the regulation says 17, 18, 19, 21. But the rules are not totally affects even like the register penalty, the other procedures, the workers are being the regulation is come in 2017. Which regulation there is no provisions at all, not that I could say that because the rules are even though you are not taking the consideration the regulation. The regulation the regulation is come 2017, specifically about the system of that. I just keep my reply note because they are not showing the document with regard to the assessment how it has been done. There are 47.70%. No, 8.7%. The commissioner has specified that he has become a base clear, which compared with March 2020. That and the regulation has come to 2017. The clear from 17, 18, 19. But the next part is very vital. The extract was the company that it's with regard to Secures Hotel. If they say they have himself has given their assessment, it is submitting the following documents as on 36 2017. That statement details July 2017 to March 2021. Fairfax copy 2018, 19, 20, 21, 2021. Quarterly with VAT returns 2017 to 2021 because stock sales, purchase deals, purchase report. But they have based on the notices, they have unique submitted their details. Based on their details on their self-assessment, and they say that we have agreed with the objections, they file objections. They come to court saying that we have been heard in terms of the regulation. Hearing opportunity has been given. An order has been passed. Not any order, I just say not any order passed under section 4 of the regulation. And it is under section 7, this is an applicable order. The commissioner passed an order. If I could have been understand one powerful judgment principle, if an violation of method is given without giving an opportunity of hearing, you could have passed an order, what is very right. But they are here, they got an opportunity, they have all the patients to show the document, but they have argued.
That is what I had asked you.
Till the submission, they are not sure if you see the step of paper so that they have been not defaulted of the tax. It would have been demonstrated in court either before the tax is not the case. It is an assessment because a lot. You have to pay taxes. While you are renting an enterprises, you paid what is the amount to pay, what is the plus one for the authority, your VAT comes and you file that extent. You are raising only this point of limitation. Instead of respect, you are raising the authority. But in the assessment, might have done a wrong calculation. But you could have been showing that this is the wrong. That has not been done, not because they come for this order only to await the progress to deposit the amount before the time. But I could have first day this court when hearing asked me the question whether it tribunal was possible. Except not whether it is possible because special features chief justice not be taken. So as if the court has passed it. Subsequently, they have in the writ petition. There are only nuances to file the writ petition is that there is no appellate trial. Do not be kindly come to page 161. But we should I not this. But page number 161 kindly come first.
Yes. One 61.
They don't insult to go with the page number 161, 24/7, 2024.
Yes, details of the appellate tribunal.
And take a stand from one hand to another hand.
Asking for the
Behalf of the client, behalf of the client.
that I can't find a repetition challenging the jurisdiction, right? Without hearing.
Yes. That is all. How long you will continue, sir? Why don't you give me a short note? Give it to me tomorrow. Yes. And and do I take it that if once this matter is decided, the other matters follow? So kindly, no, no, then I'll only say that the judgment in such and such matter will govern. Kindly conclude the, tomorrow I can hear you for some time if you like. Conclude it tomorrow, otherwise I won't have the time to write the judgment. Right? Give me a short note tomorrow also. I've heard. What's your good name, sir? Adershilan. Really? Were you here? I told him I'm very impressed with his preparation, with his speech, diction, everything, delivery. Yes, excellent. Whether you win or lose is absolutely irrelevant. Yes. Heard Mr. Elango, learned advocate for the writ petitioner. At length. Stop. He does not conclude. Paragraph lists this matter once again. Tomorrow's date. I'll give you half. 2 and 2:30.
Yes, sir.
Tomorrow marked 2 p.m. Where did you do your law degree from? Chennai. And when were you enrolled? Last year.